Welcome to the Beresford Booth webinar program. This week, I will be presenting the second in our four-part series of Understanding Trusts. If you recall, our first part in this series talked about what a trust is. We first defined what a trust is, and then we discussed the various terminology associated with trusts, such as a trustee, a trustor, a beneficiary. We also discussed the different types of trusts. So today's question is, now that we understand what a trust is, do I need a trust? The majority of the questions or the situations that come up in this situation has to do with estate planning. Do I need a trust versus a will? And in that context, we would be talking about a revocable living trust. So that's what I'm going to spend most of the time today talking about. We will also talk about testamentary trusts and other types of trusts that you may need to consider given your specific situation. Whether or not you need a trust is one of those questions that has an answer. Well, it depends. There are lots of reasons to have a revocable living trust, and the reasons need to be weighed against the downsides of having a trust. So a revocable living trust is a trust that's created while you are alive. You can create one on your own. Typically, married people will create a revocable living trust where they are both the creators of the trust itself. A revocable living trust is useful for avoiding probate. If you're concerned about privacy issues, ensuring that management of your assets is a seamless process, ensuring that the trustor or both trustors' wishes are followed, and then also, in some situations, management of out-of-state property. So let's take those one by one. First, a revocable living trust will help you avoid probate. It's helpful to understand what a probate process is. Probate is where a person's last will and testament is submitted to the court. The court authenticates that the will is valid and then appoints a personal representative to administer the deceased person's estate. That is, pay off their debts, determine what their assets are, and then distribute those assets according to the person's will. That is the probate process, quote unquote. The one reason to avoid probate is that it can take time to get the personal representative appointed. It's not immediate. It rarely happens within a couple of days of a person's death. It can take up to a week or longer, depending on the circumstances. If you submit a will to probate and you are appointed as personal representative, you have statutory duties under Washington state law that you're required to follow. And even though Washington has a very easy, uncomplicated probate process, if you are the personal representative, there is very little court intervention. You're not required to go to court to obtain permission to take most actions. But once you have established a probate, filed something with the court does have oversight of you as personal representative. A second reason that some clients like to choose a revocable living trust versus a will is for privacy reasons. Your will generally have your your choices about where your assets are going to be distributed, who your family is, how your assets are going to be distributed. Sometimes there are specific dollar amounts to a specific bequests that perhaps you would rather have those remain private. If you use a will for your disposition of your assets, that is eventually going to be made public, and anyone can obtain a copy of it. If instead you use a revocable living trust to dispose of your assets, the trust itself is not required to be filed in the public record. So this is especially true if you have quite a large estate. It's also true if you may be distributing your assets in different proportions to different children or grandchildren. Perhaps you're even disinheriting a child or a grandchild. That all can remain private if you use a revocable trust. One of the most important reasons that people like to use a revocable trust is for management of assets while the trustors are living and also after they have passed away. If you create a revocable living trust, you and perhaps your spouse are going to transfer your assets into the trust. That just means you're going to retitle them from your individual name to the name of the trust with you as the trustee. Once those assets are in your revocable trust, you manage the assets in pretty much the same manner that you had done so before. You are the trustee, you're the creator of the trust, and the trust is for your benefit. So once the assets are in the trust, the owner, quote unquote, of the assets does not change, but the trustee can change. And this can be helpful in a lot of situations. Let's take, for example, that a married couple has created a trust and one or both of them just doesn't feel like managing trust assets anymore or taking care of paperwork, paying bills. Well, they can hand that off to one of their kids, for example. And so while they still enjoy the benefits of the trust and can control how the assets are distributed, somebody else is in charge of doing the day-to-day management. A revocable living trust operates the same way as a will. So, for instance, if we have a married couple, they may both just have individual wills, and those individual wills determine how their share of their joint assets are going to be distributed. With a revocable living trust, each spouse still has the same authority and power to direct how their share of the estate is going to be distributed upon your death, but instead of having two documents, everything is contained in the one document. And lastly, if you own real estate in another state other than Washington, it's a good idea to have a revocable trust. This is so that you can not only avoid a probate in Washington, but also in another state. And some states, such as California, have a very prolonged, difficult probate process. And avoiding a probate administration for property in another state is very much desired, particularly if you have just a small piece of property that may not be worth a great deal of money, but you may have to spend a lot of money establishing a probate in another state, hiring an attorney in another state, just to put that property in your name. So that's always a good reason if you do own property out of state, is to make sure it is in some sort of revocable trust in order to save having to do an out-of-state probate. So here's an example of a typical revocable living trust and why you might need or want a trust. Bob and Emily are married. They live in Washington State. They've lived here their entire lives. Everything they have is community property. And they decide that they like the idea of privacy for their revocable living trust. Also, they have a vacation home in California. So they create a trust. They retitle, transfer all of their properties into the name of the trust and their financial assets as well. And they continue managing and controlling those assets in the same way they did before they had the trust. When Bob passes away, the terms of their trust state that Bob's share of the assets are going to be distributed in a certain way. They may continue in trust over which Emily will have continued authority over, or he may have directed that his share of the trust assets are instead put into another trust for estate tax savings purposes. If Bob does decide that his assets are going to be held in a trust, that would be for Emily's benefit, for use during her life, and then Bob will get to decide where the remainder of that trust is distributed upon his death. That's the same whether it's a trust or a will. And when Bob passes away, Emily now becomes the sole trustee of the revocable trust. However, as the years go by, Emily develops some memory issues, and managing the trust has just become a burden to her, and so she decides she wants to resign as trustee. She's still the trustor, the creator of the trust, and she's still the beneficiary, but someone else is going to take over management of the assets. And according to the terms of the trust, that is their son, Howard. So Howard steps in, he acts as the successor trustee. And even if Emily's condition would get to the point where she's fully incapacitated, because most, if not all, of her assets are held within this trust, there would be no need for a conservatorship, as Howard could just continue managing the assets for her benefit. And then upon Emily's death, Howard continues in his role as successor trustee, and he gathers all the assets, pays all of her debts, and distributes the remainder of the trust assets according to the terms of the trust. There are considerations if you're trying to decide if you need a revocable trust or not. One of them is the upfront cost. Typically, the fees to have estate planning documents such as a will, powers of attorney drafted are usually less expensive than if you are going to create a revocable trust. There are also actual costs associated with creating a trust. For example, if you have real property that you're going to transfer into the trust, that has to be done by way of a deed, and there are recording costs associated with that, with recording a deed in the county where the property is located. The other consideration, even though you may have decided, yes, I would like a trust, I think a trust would fit all of my needs, if you don't transfer all of the appropriate assets into your trust before you pass away, then a probate is still going to be required. And the process of retitling bank accounts, transferring real property can be end up being more of a burden than you might have expected. Lastly, not all assets are appropriate to put into a revocable trust. Retirement accounts are one good example. Life insurance typically it does not, but there might be other interests that you have, such as a family-owned business or a limited liability company, a partnership, that you may not be able to put into or retitle in the name of your trust, or it just might not be appropriate. So those are items to consider when you are trying to determine if a revocable trust is a good fit for you. So the second type of trust that I wanted to talk about today, when you're considering, do I need a trust? That question still may come up even if you don't choose to go the revocable trust direction, but you want to just stick with the standard last will and testament for you and perhaps your spouse. Contained within your wills, you still may create a trust that comes into existence upon your death. This is called a testamentary trust. And the terms of that trust can be included in a revocable trust, and it can also be included in your last will and testament. If it's in your last will and testament, there may be several reasons why you decide that you want to create a trust upon your death. As we talked about with revocable trusts, a marital trust may be something that's desired upon your death. You may want to provide for support for your spouse, and you also may want to take advantage of estate tax savings vehicles, and so you would, in your will, it would contain directions of where your assets are to go and if they're to be held in a trust or not. Many trusts have a trust for an individual's children. This could be whether your children are currently minors or not. In the event your spouse predeceases you, or in the event you're single and you have children, you may, instead of giving assets outright to your children, you may want them to be held in a trust for a certain amount of time to protect the assets, to keep them for the children. If your children are minors, you definitely have to have the assets in a trust. And we will go through some examples of both a marital trust and a trust for your children. We are seeing more and more people include trusts for their pets in their last will and testament. This usually provides that their pets are to be given to specific people, a close friend, another family member, and that those people are given a certain amount of money to continue to care and provide for the pets. Let's go through some testamentary trusts that you might typically see in a last will and testament. A marital trust is also sometimes called a credit shelter trust, a disclaimer trust, Q-tip trust, or a family trust. But the idea behind whatever this type of trust is called is that the spouse who has passed away wants to take advantage of tax planning to avoid estate tax, and or controlling where his or her share of the assets are going to be distributed upon the death of the surviving spouse. And many times the only reason that a marital trust is desired is for estate tax savings purposes. Also, many other times you may have a blended family, second marriages with children. Both of you have children, and you may want to provide for your spouse while he or she is living, but then also be able to decide when my spouse dies, I want these assets to go to these people. And so that's another reason that a marital trust sometimes are used under a last will. As we talked about before, trusts for your children or even grandchildren are very common, specifically if there's a possibility that you want to leave assets to your child or grandchildren and they're minors. You want to make sure that some sort of trust is set up. Another purpose for having a trust for your children or grandchildren is to protect the assets, allow them to grow until the children reach a certain age and perhaps an age of where they have financial responsibility. So that someone who's very young, 18 or 21, isn't receiving a large inheritance and just the risk that a younger adult may not invest it properly or maintain the trust assets. A third type of trust that is very common in a last will and testament is called the supplemental needs trust. You may have heard this called a special needs trust. This is a specific type of trust that is created for the benefit of a person who is receiving some sort of a governmental aid, to the extent that if they were to receive a large inheritance, their eligibility for that aid would they would be disqualified. And so if instead the assets are transferred not to this person, but to a trust for their benefit, then the assets are there to provide and supplement any other aid or assets, that income that they're receiving as part of their governmental benefits. It's a supplement to it, but it also doesn't make them ineligible to receive those assets. So that's the type of a trust that we're seeing more and more in wills, even if you're not aware of any of your beneficiaries who may need that kind of a trust. And we like to recommend putting some type of provision for a supplemental needs trust in your last will or even your revocable trust to sort of anticipate unexpected things that could happen in the future. So here is an example of a marital trust. Bob and Emily, again, have each executed their own individual wills. Each of their wills provides that a marital trust is going to be created when the first spouse passes away. For Bob and Emily, the reason for doing this is to help reduce Washington state estate taxes. So when Bob passes away, his will says that the marital trust is going to be funded with the current Washington state exemption amount. That amount is going to be sheltered from estate tax. And Emily receives the rest of Bob's assets, and now Emily has her assets in her name, and she has a marital trust for her benefit. Upon Emily's death, the marital trust is distributed according to the terms of Bob's will, which stated that when Emily passes away, the marital trust goes to their 3 children. And Emily's share of the assets are distributed according to her last will and testament. Here is an example of a children's trust. This is an example of a single parent, which brings us to a good point. It's not just married couples that either would want to create a revocable living trust or a testamentary trust. Single people have the the same needs and purposes for either a revocable trust or a testamentary trust. In this example, Dorothy is a single parent. She has 2 minor kids, and she wants to make sure that her children are provided for financially if she passes away. So in her will, a testamentary trust for each of her children is created. Upon her death, the assets are going to be placed into this trust, and Dorothy has nominated her favorite aunt, Auntie M, to act as trustee. And in her will, Dorothy has laid out the provisions of how Auntie M is going to distribute these assets on behalf of her children, and provides specific directions. Is there for their support, their education, their welfare? Is it for travel? She could have even included that the trustee could distribute assets for starting a business, adopting a child, getting married, any of those things. Basically, that Dorothy has decided this is how she would like to see these assets managed and distributed on behalf of her kids. And then Dorothy has stated that at age 25, 30, and 35, the children are going to receive a portion of the principal of their trust for them to use as they wish. That's an arbitrary age that Dorothy decided. She felt comfortable that this is the age her kids could receive a large sum of money. Many parents choose a younger age, and some parents even choose an older age, or they choose to have the trust for their children's benefit actually go on for the entire life of the child. Again, that all depends on your situation, the size of your estate, your family situation, whether or not you would want or need a trust. We've already talked about other types of trusts, such as the pet trust. These are a little less common types of trusts, but you might have heard of them. And your situation, you may actually want or need these types of trusts. A charitable trust is just like it sounds like. It's a trust that is set up so that a charity or charities receives the final amounts of the trust upon your death. An education trust is a favorite of grandparents, where they want to set up a trust to provide resources for education expenses for all of their grandchildren. You may have also heard of an irrevocable life insurance trust. This is a type of trust that is used by many individuals when they want to be able to provide assets for payment of estate tax upon their death. So basically, the answer to the question of do I need a trust, again, is it depends. And the point that we hope that you've learned here today is that the answer can never just be a quick yes or no. And you should talk to a trusted estate planning advisor and give them all the information about your family situation, your assets, and work with them to determine what the answer is to that question. If you have any questions, please contact myself or my colleague, McKenna. We'd be happy to talk to you, and we will be seeing you in the future for the third part of our series. Thank you.